Yes, good afternoon to you.
I want to request that you relax because I'm seeing you at attention. I want to assure you that in that dock where you are standing, even in the morning, even yesterday, even last year, even some years ago, people have stood there. Eh? So when you are standing there, I want to feel like I'm communicating with a person who is relaxed. I don't want to see that tension. All together, Musime does not mean the end of life. Even the relatives who come, I like a court which is a free environment where everybody is doing his work professionally and according to the circumstance of the case. So I want to encourage all of you to relax down, because when you are an accused person and you want everybody to breathe in and out, in, out, lastly, in, out. Okay. COVID-19 that you are also all not aware, is it? Or it is? Eh? Eh? Then you can put your masks back. Eh? These people, so many eyes, they're also interested in knowing who exactly you are. Eh? So you can remove briefly, and then if it is for your health reasons, you can put it back. But I hope we are not yet there. Eh? But I want you relaxed. Remove, then you relax. Please relax. I feel good when I have a relaxed audience. I almost deserted the legal profession to become a social worker. And every time I find people not relaxed, I think about it so dearly and deeply. But I'm now too late. I'm now too old to change a profession. I have to carry the cross. Please feel relaxed. You are not the first people to be accused. It does not change anything. There is a certain procedure that the law must take before a case is concluded. It is like when a child is born. When a child is born, he must, after growing, he must go to school if he has to be a reasonable parent. Then from school, he or she must identify somebody's father and agree. So everything has a process. Now let me take you through the process of a criminal trial. The process of a criminal trial begins with investigation. It started a long time ago. You don't have to fear this stage. It started when you didn't have some information about you. Then from there, some people who may not even be here conducted the investigation, started the investigation, or took stride and reported maybe at police. It could have started in the office and the rumors. I don't know where exactly it started. Then a matter was reported at police. Then from there was investigation. When investigation began, then there was correspondence between police and DPP. Then from DPP, when DPP was convinced that there is a case or their evidence can be sufficient to warrant a case, then they directed that you should be charged. Then a charge sheet was prepared. Maybe it was taken to the okay, this one is not a requirement. Okay. But if it is a requirement, they would take it. You don't understand court procedures. And I like it when court users, including you, who are privileged not to be in the dock today, but all of us can be candidates. Yeah? We need to understand one another and feel relaxed. You are not the first people to be accused of obtaining credit by false pretense. Others are already in prison serving. Others finished serving the sentence and they are out. Others came here. If there was no evidence, they are acquitted. And similarly, you also are going to go through the same process. When you stand outside there and look that side, you think the heaven is touching that hill of Nabu, because you see the sky as if it is touching some topest, any BS. But between me and you, because you have traveled there, you know that after any BS, there is another valley down there. And life is like that. There are moments when you have had flourishing life and everything is moving fine. And this is a time when life is at the bottom. Accept it. In all situations, life must move on. But it should never affect your conscience. It should never affect your thinking. It should never affect your lifestyle. Some of you, if you remain at tense, you can even develop pressure. And sometimes, when in the effort to stabilize your pressure, you can end up destroying your body and become a pressure patient for no reason. For the wives and spouses or spouses of these people here, you are lucky that they are here. What if they are pronouncing them dead in a hospital? You say, we are sorry, and you know how doctors package themselves. We are sorry we have lost him. Would you be as sad as you are? These ones are being accused. They will either be convicted or acquitted. But they can't be convicted today because today has its own what? Process and procedure. When you come from home with some expectations, accept to learn according to acceptable standards that is governing the environment. I want to tell you from the beginning that according to the charge sheet which is before me, if you are a spouse of any of these, please know that you're not taking your husband home or you're not taking your wife home. Why? I want you to die if you think you can die as early as now, before I start. Why? The charge sheet has a count of money laundering. And according to the law, according to people who enacted the law of money laundering, they felt like a magistrate of my level is too small to handle a case of money laundering. But the law also requires that whoever goes to the father must go through the what? The son. So you can't go to the high court before without passing through the magistrate's court. The lawyers know. So you must go through me, then go to the high court, answer the charges. If there is no evidence, they will acquit you. If there is evidence, they will convict you. But the good news to you is, whoever has gone through this court has either been convicted or acquitted. Others have had their cases withdrawn. Even yesterday, some experienced withdrawal of cases against them. So there are those three sure deal methods. A case can be withdrawn against you. There can be no evidence and you are acquitted. Are we together? I want to talk to you. Until you talk, I will not go to office. Are we together? Musimi, Julius, are we together? To prison. It is not like this magistrate, because I'm in a mask. No. The law dictates that you should go. And if you want to apply for bail, then you have to apply it in the what? Then between here and prison of a case, it can be short or long. Please make sure that you listen very carefully, because this is a court of integrity. We owe you a duty because judicial powers is driving from the people, there is somebody who is dying amongst you. Because his dream and his prayer request, some passed through the church, and they prayed that, release my husband, release my wife, release my everybody. But today, for once, the Lord didn't hear your prayer. He has made his God. Are we together, members? Okay? Erina, I am assuring you, I have no doubt. It is unfortunate that the prison officers here are not here today. You will find there are very many ladies, very big you for the tour you are going to make. Actually, I want to give you an assignment. As you go to prison, because it is a must, my hands are tied. I have no powers whatsoever. Even if you are my brothers, even if you are my sisters, I have no powers whatsoever to talk about your getting out. When you go to prison, I'm giving you a simple assignment. Before you move to the High Court, where is your destiny? Use this time to study whether you can withstand the period prescribed by law under the Anti-Money Laundering Act. You'll be there for a short time. I see you have hired powerful lawyers, so they will fight it and apply for bail in the High Court. Soon you will get out and you'll get maybe your bail, because these lawyers will know them. Eh? But for now, they know and they agree with me that I don't have powers to do anything in as far as handling your case is concerned. But for the time you will be there, please, you study the conditions of the prison and see whether you can stay there for the time the law provides. If you find that according to your setting, according to the comfort zone you have been in or you are living in, you can't withstand those prison conditions, there is still hope. If there is evidence, the best advice is, even when you go to the higher court, the best advice is that you enter into a plea bargain, whereby you agree with the state and say, but you know what? Much as there is evidence, the punishment provided in the law is too harsh. Me, I don't want to waste the state resources. I want to admit this case. What do I need to do? Put right the wrong, then get a smaller punishment. That is one only way. 2, if there is no evidence, the respected advocates, they will help you. Esoke rwako teko zechi teto wadewe imiro kwanga tainachi na yetu jakulwana kirabike nti abantu bafe bakoze eki. Some of the lawyers will address, and indeed they will do what they talk. They will apply for bail in the High Court, and you will get it, because these are bailable offenses by the court, which has unlimited jurisdiction. But still, when you are on bail, use that time to study your case. And when you are opening up yourself to your lawyers, appear as if you are in a bathroom. How many of you go to bathrooms with knickers and boxers? Yeah? That's how an accused person should appear when he or she is appearing before his lawyer. Tell your lawyer the truth of exactly what happened. When you tell your lawyer a lie, or choose to defend yourself before your lawyer, he will give you long advice. It is like the equivalent of, you know that you are feeling pain in the private parts, and the problem could be gonorrhea, and then you go to the hospital, I'm feeling headache, hoping to get Panadol, and you relieve pain. If they give you medicine for headache, gonorrhea will not go, and it will definitely kill you in the High Court. Use that time to discuss with your lawyers, inform them the best you understand the case. Don't defend yourselves before your lawyers, because your communication with your lawyers is protected by the law. The lawyer whom you have disclosed your experience of how you committed the case is not allowed to go around giving even evidence against you. No. He is prohibited from going to the state and say, do you know what? Client wange yakola omusango. No. The law protects that. So, address your lawyers the best you can understand whatever happens. That's when you get advice from those professional guys. If you choose to hide yourselves, to hide what you know about the case, they will not help you. And I want to also remind you, as a former lawyer and as a former prosecutor, that cases that if they say somebody got money on your account or got 700 million or billion, nobody can carry 6 billion. It either was put on account, look at it and see how it moved. Yeah? You will react with you. You may not be the owner of that one, don't nod the head, but you could have assisted in carrying the bag. Yeah? Yeah? You could have assisted in carrying the bag or approving or doing anything. Those lawyers are going to advise you about your cases. Yeah? These are not hard cases. Cases in this court, they are only complicated by the nature of their chosen persons, because you are powerful people, the nature of serious advocates you bring, who will fight tooth and nail to make sure that you get the best of the best as the value you have paid for. Some of you are already saying now this one is wasting our time. He began by wasting our time before. He's now wasting our time here. We have our other issues. Yes, but at least I'm seeing at least a handful of you trying to relax a bit. And I want to thank God. For those who are not relaxed at this stage, please, you relax the next time. Let's go to court. You will talk and make sure that the last man in the corner hears. Is there anybody not hearing me? Eh? I'm asking, do you hear me? How about you with the shades? Do you hear me? Yeah, make sure your targets, and for you are a bit near them. Make sure that your target is that man in the corner hearing you and the other gentleman in the corner hearing you. Okay? So, Mr. Musime Julius, which language do you best understand? Word, you are baptized A1. When we talk of A1, we are referring to Mukisa Julius. Then, Nabisubi Erina. Which language do you best understand? Mr. Semogerere, Fred, what language do you best understand? Mr. Tumuhimbise Crescent Tivarwe Sereka. No, Tivarwe Sereka, yes. Then you stand in your order. Going forward, you are A4. Stand in your order. You understand what and what? A. Then A2, Nabisubi Erina. It is alleged you are a female adult, Muganda by tribe. You are a relationship manager, Telecom Equity Bank, and resident of Katare Village, Maki in the Sebagabo municipality in Wakiso district. Okay? Then A3, Mr. Semogere Fred. It is alleged you are a male adult, Muganda by tribe. You are a banker with Equity Bank. You are a resident of Unamwaya, Ngobe Village, Maki Indie, Sabagabo municipality in Wakiso district. Then A4, Tumuhimbise Crescent, Tiva Rwesereka. It is alleged you are a Munyankore by tribe, relationship officer, Equity Bank. You are a resident of Chengera Town Council in Wakiso district. Then A5, it is alleged that you, Mr. Asimo Wycliffe, you are a male adult Munyoro by tribe, a distribution and marketing consultant and resident of Magere Kasangat in Wakiso district. Is that true? Okay. So, we are going to use English and stand charged with the offense of obtaining credit by false pretense, contrary to section 308A of the Penal Code Act, cap, I think 120. There is some zero missing. Take note of that state. Nabisubi Erina, you stand charged with the offense of obtaining credit by false pretense, contrary to section 308A of the Penal Code Act, cap 120. The particulars of the offense against you are that you, Nabisubi Erina, between the year 2021 to 2024 at Equity Bank, Church House in Kampala City, being employed as a relationship manager Telecom, incurred a debt of Uganda shillings 6 billion 550 million from Equity Bank, falsely representing that the loan were being applied for by Najemba Gladys, who you fronted as having fulfilled the bank requirements for accessing the loan, whereas not. Erina, I want to hear you. No, I want state. Hold on. I want to hear if she has heard or has understood. Yes. But even if she was to answer or to plead this charge, she can plead it, but even when she goes to high court, she pleads to it. But because she's going to be charged with others in a money laundering case, then she doesn't need to answer it. So hold on. Thank you for your wise counsel. So, Erina, have you heard? Speak loud, I want to hear you. Have you understood? Yes, like I told you earlier, while I have jurisdiction to entertain your plea, but the fact that your case is connected and you are charged jointly with other colleagues of yours on charges of money laundering, I will not ask you to plead to these charges. You will plead to them before the court with jurisdiction to handle both obtaining money by obtaining credit by false pretense and money laundering. So my duty is to ensure that you have heard and you have understood the charges against you. And feel free, if you have not understood, you can ask me to repeat. Section 308A of the Penal Code Act, and the particulars of the offense are that you, Nabisubi Erina, between the years 2021 to 2024 at Equity Bank, Church House in Kampala City, being employed as a relationship manager, Telecom, incurred a debt of Uganda shillings 300 million from Equity Bank, falsely representing that the loans were being applied for by Nagawa Ratifa, who you fronted as having fulfilled the bank requirements for accessing the loans. Have you heard? Have you understood? You are advised not to plead to these charges, as you will be given opportunity to plead to the charges before the High Court, which has jurisdiction to try both obtaining credit by false pretense and money laundering. 61A of the Money Laundering Act of 2013 as amended. The particulars of the offense are that you, Nabisubi Erina, between the years 2021 and 2024 at Equity Bank headquarters situated at Church House in Kampala City, being employed by Equity Bank as a relationship manager, you intentionally impeded the establishment of the true ownership of Uganda shillings 6 billion 500 million, which you fraudulently obtained from Equity Bank as a loan through account number 1032100370335 in the name of Najemba Gladys, purporting that the said funds were applied for by Najemba Gladys as a loan, whereas not, knowing that the said funds were a proceed of. So you are advised not to plead to these charges or to the charge under count 3 because court does not have jurisdiction to entertain your charge. While the court has jurisdiction to entertain your plea under count 1 and 2, court does not have jurisdiction to entertain your plea under count number 3. And for that matter, having heard and understood, you have an opportunity to plead to the charges once you appear before a court with competent jurisdiction, which is the High Court. Count 4. of the Penal Code. B, Section 116 and Section 113 as amended. And the particulars are that you must, between the year 2021 and 2024, at Equity Bank headquarters, you intentionally concealed the true ownership of conspiracy to defraud contrary to Section 309 of the Penal Code Act, Cap 120. The particulars of the offense are that Musibe Julius, Nabisubi Erina, Semogere Fred, Tumuhimise Crescent, and Asimo Wycliffe between the year 2021 and 2024 in different places in Kampala district and Wakiso district. You conspired together to defraud Equity Bank of Uganda shillings 62 billion shillings by fraudulently causing the disbursement of unsecured loans to unqualified people. The prosecution is alleging that you worked together with all those people to defraud Uganda shillings 62 billion. And they are a bit specific that you did it in Kampala and Wakiso districts. Have you heard? Have you understood? While I have jurisdiction to entertain your plea, but conspiracy is conspiracy to commit a felony I don't have jurisdiction over. And for that reason, I advise you not to plead to this charge, because the court presided over by myself does not have jurisdiction to handle the offense which is a result of this. The same advice applies with the necessary modification, and you are accordingly advised not to plead to this charge, because court does not have jurisdiction in the matter you conspired to commit. Mr. Wycliffe, did you hear what I read to you as statement of the offense and particulars? Have you understood? So, you are equally advised not to plead to this charge, because the alleged conspiracy arose from the charge of money laundering. That is my major duty. Maybe state you can advise me.
Solomon Webalarali.
Solomon
Webale Arali. Your Worship, we are most obliged for the guidance to the accused, who are also our clients, on the counseling you have given them to take the situation as it is. We are most obliged. Your Worship, we also pray to our colleagues here, the state, that they avoid to us the charge sheet and all the disclosures in the most convenient manner, and we seek utmost cooperation with our law colleagues to avoid us the necessary documents for purposes of applying for bail in the High Court and preparing the defense of our clients.
Disclosing the charge sheet. But however, as I've intimated to court, the investigations are still ongoing. Your Honor, we cannot at this stage fully disclose to the defense, since the inquiries are still ongoing. Nevertheless, we have no problem with disclosing to them what we have. the convenient time, since it's their constitutional right. Say, but we'll be communicating.
Said, with greatest respect.
Yes, Your Honor.
This is a charge where the accused people are not even allowed to plead to in the court they are appearing in. They may wish to plead guilty, but they are not allowed to plead to the charges. So when you say you can't with exactness state when investigation is complete for them to appear in the High Court, you are practically and technically saying denying them an opportunity to plead to the charges. So for that reason, you may not be in a position now, but I want to put you on notice.
Yes.
I've actually even written it even
Before hearing from you, I'm going to read what I've summarized. Charges of this nature, we normally encourage that investigations should be nearly complete by the time you bring them. Because you just imagine if you are to spend the other 6 months and you are holding a person who has not been given an opportunity, just an opportunity to say, do you know this offense? Yes. Don't you think you are condemning this person unheard? So I want to encourage you to speed up investigation and ensure that that the case moves to the next level. And as you may know, I will summarize this. What I'm saying, I'm going to summarize them in what I've just put down. As you may know, we have the High Court practice rules. And as far as I'm concerned, I expect to see you in official capacity as accused persons, as state prosecutor handling this case, as defense lawyers, not more than 3 months. So, if it so happens that investigation requires more 6 months, then it was premature to bring these people in court. Because after 3 months, I will refer you to the next what? You'll be occupying my space for no reason. So be it as it may, this being the first day, I want to encourage you to speed up investigation. Otherwise, it would be unfair. And we as court, we have a mandate, we have a duty to ensure that justice is not only done, but is also seen to be done. It is unfair for an accused person to appear in court and spend more than a reasonable period before he's given an opportunity to plead to the charge. You may, for instance, assuming all of these people intend to plead guilty, they don't have the right just to plead guilty. So they have to wait for the opportunity. And that, so give me a date. And that date was determining maybe the adjournment I can give you, but considering that they are going to seek bail, I will give you a short adjournment of not more than some 2 weeks, because we need to always update them. So on next adjournment, I expect, on next adjournment, I expect you to address me on when investigation is going to be completed, because it is of essence. That knowledge is of essence. Yeah. No. 2 weeks from now, it is a mention. But of course, 2 weeks will appear when I am on leave, so you can get after 11. But that does not mean that you will stay in prison for up to 11. The instructions you give to your lawyers, the instructions you give to your lawyers, will determine how long you will spend. Your lawyers can proceed to the High Court and apply for your can proceed to the High Court, and by the time you come back, you could be on bail by the High Court. So the quicker your lawyers act, the better for you. But as this court, we don't have jurisdiction to entertain your bail application. Next month, April. We can't adjourn for a very long time, but I'm adjourning. But we can even adjourn for only 2 weeks, and you will appear before any other magistrate. After all, the magistrate will not have anything much to change. He will also be like myself. Eh? You don't have any powers. So, if it is in your interest, we can give you 12, you appear before me, or we can also give you earlier date than what? Than 12. But that date is not for any progress in as far as bail application is concerned. I want to be understood. It is for you to be communicated, to be updated about the status of your case. So, we can take any date, even when I'm away, any other magistrate can mention this file. Should we take an earlier date or we take 12? You had recorded 12? How many days are they to 12? From now to 12? 2 weeks only. Yeah? But in any case, if investigation is going to take long, please be at notice that you will be a participant in violation of the rights, the constitutional rights of the accused person, and court will not condone that. So we have agreed 12th of April 2024 at what time? Yeah, we shall meet here at 11 of the 12th day of April 2024. But I take note of the fact that investigation is incomplete as per the state. I am alive at the fact that justice delayed is justice denied, and also to the provision of the High Court practice rules of this division. For that reason, the state is advised to speed up investigation and ensure that the accused persons are committed for trial before the expiration of the 3 months as provided in the rules. But in the meantime, the accused person are advised, if they so wish, to apply for bail before the High Court, as this court does not have jurisdiction to entertain bail application in this matter. This matter is adjourned to the 12th day of April 2024 at 11 a.m. In the meantime, the accused persons are remanded to a government prison. Can I have those charge sheets for endorsement if you have them?
Yes.
Epa.